Hello and welcome to the podcast series Creditors Corner Legal Talk, presented by Smith Debnam Attorneys at Law, where we explore a range of legal topics impacting businesses and private individuals. So be sure to hit subscribe so you never miss an episode. My name is Landon G. Van Winkle, and I'm an attorney in the firm's Consumer Financial Services section. I will be your moderator today. Today's topic is force majeure clauses. We're going to go over what force majeure clauses are, where do they live inside legal documents, what role do they play in real estate leases, and where else do we find these types of clauses? Before we begin, I want to note the information provided in this podcast does not and is not intended to constitute legal advice. Instead, any and all information shared is for general informational purposes only. Listeners should contact their attorney to obtain advice with respect to any particular legal matter. With that out of the way, let's now turn our attention to this week's topic. With us today is Gene Chianelli and Lauren Reeves. Gene, thank you for being on the show today.
Thank you. Glad to be here.
Gene is an attorney in the firm's business law group. Lauren, thank you for being with us.
Thanks so much. This is my first time actually speaking. I'm normally moderating, so I'm a little nervous.
Very exciting. Well, we promise we'll be gentle. Lauren is an attorney in the firm's business law group. So, Lauren, just to get started, let's roll right in. So what is force majeure?
I can tell you what it means. It literally means superior force. So bring on the drama. That was excellent. Truly, it's a dramatic force that brings a force majeure clause into action.
So what does a force majeure clause do?
Well, first of all, it's contractual, so it's got to be written into a contract. And it excuses performance by a party, either temporarily or permanently. So there may be a delay, or it may actually excuse it for more than just a time, where there's an event or force that actually prevents a party from performing their obligations or responsibilities under a contract. So when it works, it relieves both parties from the liability or their obligation or responsibility. But it's got to be really extraordinary and beyond anybody's control. It's also got to be unforeseeable. So there's a lot to unpack here. And it actually has to make performance impossible under the contract by preventing at least one of the parties from fulfilling its duties.
Very interesting. So, Gene, what are some of the events that can trigger a force majeure clause?
Some specific events that are typically named in a force majeure clause include, both man-made events and naturally occurring events. So acts of God like weather events, floods, fires, or natural events like earthquakes. And then on the man-made side, wars, terrorist acts, governmental acts like condemnation, expropriation, changes in laws or regulations. It can include labor strikes and other kinds of labor disputes. And then just accidental events like the Chernobyl or the Bhopal disasters from the 1980s. Those are all commonly named events that you will see in a force majeure clause.
So what is the purpose that a force majeure clause really serves in a contract?
Yeah, so really the main purpose, and really this is a big part of contract drafting and negotiation, but the main purpose that a force majeure clause will serve is to allocate risk between the two parties or the parties to a contract, and to provide notice of events or occurrences that may cause a delay or fully excuse performance of a contract. They're just a way that parties can share or mitigate those risks. And again, that's done by defining what an event that constitutes and triggers a force majeure clause. There's also a rationale for force majeure clauses that basically says, well, unforeseen events occur, and when they occur, and no party to the contract is responsible for them, when that's the case, it's reasonable and it's equitable, meaning it's just fair to excuse one or all of the parties from performing a contract.
Okay, so I get that force majeure clauses are there to cover unforeseen events and allocate risk. But things don't always work out as planned. Does this mean that force majeure clauses are easily enforced?
That's actually a really great point, and the short answer is no. Force majeure clauses are not easily enforced, and they're difficult to enforce for good reason. The remedy, that is one party being excused from performing the contract, is an extreme remedy under just general contract law. It's something that courts really disfavor having to do. So that raises the bar, if you will, for enforcement. Again, impediments for performing a contract occur all the time. The key with force majeure clauses is that the specific impediment has to be adequately spelled out in the force majeure clause in the contract, and that's why it's when that happens, the force majeure clause is more likely to be enforced.
So, Lauren, what are some common questions that you've gotten about force majeure in your practice?
I've actually gotten most of them lately. And they're all related to leases at this point in lease contracts. And they've actually all been about this COVID-19 pandemic. And, do government shutdowns have, does that automatically make my force majeure happen? Can I rely on force majeure? It's interesting because it's all based on, hey, am I going to have to pay, or can I get out of my lease is what I'm hearing on that. Or can my tenant get out of my lease? The answer is likely not. Most force majeure clauses do not excuse non-performance, but suspend it for a time, depending on how it's drafted. And then, honestly, the tenant's still probably going to have to pay rent, or if there's a deferral of rent, you're going to have to pay it at some point. So, no, there's not an automatic deferral. It's not in all contracts. So, I usually can't answer that question really quickly without actually looking and taking a deep dive into the document and all of its amendments, assuming there are some. And so, because it's a contractual provision, the answers that I give kind of change depending on how that force majeure clause is drafted. But generally, my tenants are going to have to pay rent, and generally, I can tell the landlords they're going to have to pay rent.
So, Gene, what about you? Have you gotten any questions about force majeure clauses, particularly lately?
I have, and I'm getting a lot of questions really on two basic issues. One, should I have a force majeure clause in my contract? And two, what should it say? And the second question nowadays, everyone wants to know, is a pandemic going to be included in that list of events that triggers a force majeure clause? Which of course is natural with us being where we are with COVID. On the first question, in terms of what kind of contracts should have a force majeure clause, I generally say that it should be at least open to discussion. Anytime there's a contract where the parties are going to have a continuing relationship, a longer-term relationship, after the contract is executed, as opposed to, a one-off or a transaction like a sale where, there's a closing, and once the closing occurs, that's kind of it for the relationship between the contracting parties. So that's one type. Another type is, any kind of contract that calls for performance in the future. So, to Lauren's point that, she's seeing them so much in leases, or dealing with them so much in lease contracts.
Yeah, and Gene, we as attorneys are looking very closely at how we draft these clauses moving forward. Some clients are still really want them. Some opposing parties will not allow them in. We're trying to be able to craft these in a way that cover more specifically some events, but don't leave out others, because this is new, much like what happened, September 11th, 2001. That changed the way that we drafted some documents, and this will forever change the way we draft some documents as well.
So, Lauren, I heard you say earlier that force majeure basically has to make it impossible for at least one party to fulfill its contractual duties. Do we really mean impossible? I mean, what does impossible really mean?
Yeah, that's hard. Impossibility is really hard to prove. And generally, it's going to have to be proven in court because these are questions of fact, right? So you can have either your tenant or your landlord or your party to your contract raise this force majeure, and there's got to be some notice of that generally. But the other party doesn't have to automatically agree. And so usually there's a fight about this, and usually it's a court making a decision. It'll be interesting how this plays out over the next year and even in the next few months on what these things mean. So impossibility, that's a tough one. It's got to be proven, and it can get really expensive to do that. So let's just talk about a couple of examples, and I'm going to drive you nuts by not giving you a real answer. So it depends. So just be prepared for that. So restaurants and hair salons. They were shut down at the beginning of this pandemic by government intervention and by not allowing it to be open. So they both rose to the occasion and figured out ways to still run their businesses, maybe not at full capacity, but restaurants were able to do carry out and takeout orders. They changed their menus. They did a lot of things to do this, and hair salons couldn't cut hair, but they did the root touch-up kits and a lot of order pickups for shampoos and offered things on that, and online ordering, Instagram through ordering. So they were really creative in how they approached this. So that begs the question of, was the performance impossible? Maybe, but they also kind of did some things. Difficult performance or really expensive performance, that's just not going to cut it. That's not impossibility. It really has to be impossible so that the circumstances prohibited or so significantly delayed it that it counts as impossible.
So the impossibility, this is a defense to contract enforcement, right?
Yes.
And so if I'm the one under the contract saying I can't do it, then do I have the burden of proving that?
Yeah, you're going to have the burden of proving that. And like I said, you're not proving it to the other party generally. You're proving it to a court, and that gets expensive, and that's a fact-finding mission, and one that we just don't know how it plays out right now.
So what about a case where it may not be impossible, but the eventuality that comes up is something that was unforeseeable?
Well, unforeseeable is another requirement. So it not only has to be impossible, it's got to have been unforeseeable. So this is going to get interesting now as well, because we don't know how this plays out in court. And there's been one government shutdown already. Who's to say there won't be another one, and whether or not that's foreseeable at this point? Or if pandemics become a thing, which we hope that's not the case, does it automatically make a government shutdown or a restaurant shutdown or some kind of, public stopping or interference with those businesses? Is that automatically foreseeable now? I'm not really sure of the answer, but it's interesting. I also want to talk about mitigation because I didn't mention that before, but there's always a duty to mitigate. Meaning the person who's trying to, or the party who's trying to rely on force majeure will have to prove that it's taken reasonable steps to avoid or lessen the consequences triggering the force majeure. So that's kind of tough because you've got to be able to mitigate damages, which in the restaurant and hair salon example was a great way of them doing that. But it also means that they're going to have to not be alternative ways for performing under the contract. This all goes back to the impossibility again. Alternative ways of getting there so that they can perform the duties may mean that impossibility is not met. Again, this is all really fact-specific and up to a court.
So, Gene, how does a party to a contract go about invoking force majeure? Do I just send a letter to the other side and say, "Act of God, I'm out"?
Well, that's part of it. I mean, you've got to give the other party notice. So, in other words, the party that is seeking to not perform under the force majeure clause has got to give notice to the other party or parties who are expecting performance to occur. That again, the force majeure clause is being invoked. Sometimes that notice comes in or through litigation. So you'd have Party A trying to enforce the contract as written, sues Party B. Party B, raises force majeure really as a defense and saying, to the court, "Hey, excuse me, from performance based on this force majeure clause. Now, that when we're talking about that stage, we're obviously past the point of of performance or expected performance occurring. There are some things that can be done well before that. There are things that can be done before you get to that point with how the force majeure clause is negotiated and drafted that can make that later stage or that end stage where you're trying to enforce it through litigation, let's say, much different. And that's where, again, good negotiation between the parties and their attorneys and good drafting on the part of the attorneys drafting the contract can really pay off.
So if it's not a get out of jail free card, then what does it actually do for me if I'm in a contract?
Yeah, it depends on how it's drafted. It depends on how the force majeure clause is drafted. I mean, most clauses, for instance, aren't going to specifically include a pandemic, again, referencing our current situation. And some of them may not even mention government shutdowns. I mean, I talked about the different events that typically trigger force majeure clauses, but a force majeure clause in practice can be, a couple of sentences that will basically, give a couple of very broad categories of events that are going to be excused, and then it's up to the parties or a court to figure out, when an event that arguably triggers the force majeure clause occurs, to determine whether that's contemplated by the contract as drafted. So, a lot of force majeure clauses don't, again, include pandemics and government shutdowns. So, as Lauren mentioned with 9/11, we're changing some drafting moving forward, and this also occurred when the financial crisis hit over a decade ago in 2008, 2009, that range. The pandemic is really new. I mean, it certainly wasn't expected. I mean, it's the first time in really 100 years that there's been this kind of pandemic that's been worldwide and so significant, and it's on everyone's mind these days.
So, Gina, I want to jump in here real quick and say that, so far we've kind of been talking about, whether generally the liabilities are there for this and that the responsibilities can be met. There is some non-performance that force majeure may excuse under the lease based on how it's drafted. For example, if there's a continuous operation clause or a prohibition in the lease against going dark, a tenant's going to be able to say that it's pretty impossible to not have its lights off and not be operating if the government shutdown applied to it. But that obligation to pay rent is still there. So it's not the get out of jail free card, but it does excuse some performance under leases in some circumstances.
So it might be a stay of execution, but I still have to pay the bill at some point.
Very, very well said.
Okay, so what are landlords and tenants doing about all this?
And this goes right back to Gene's point that it's a great time for negotiation and creative problem solving. What I've been seeing is some willingness to negotiate on the part of landlords and tenants. The discussion is there, and based on the relationship they have, the negotiations may vary wildly, particularly depending on whether the landlord has a mortgage on the property or not, and what that relationship is. I've seen a lot of rent deferrals with payment plans, some reductions in lease terms, and some other creative options. But I'm not seeing leases being canceled unless they're paying out early. And there may be a discount to be able to do that, but that's generally the trends that I'm seeing. The moral of this force majeure story is that it's a great time for landlords and tenants to come up with alternative payment structures and work some things out and show some humanity. I'm seeing it sometimes, not so much others.
So, Gene, what about insurance coverage? Is this something where force majeure might come in and play a role in insurance issues?
If we're speaking about loss of income insurance, really it's likely a a no-go. So you're not going to be able to generally say, okay, well, I can't rely on my force majeure. Can I say, can I go to my carrier and say, okay, I need coverage under my loss of income policy? Those are all, again, like with force majeure clauses, all about the triggering event. And what most loss of income policies require is some kind of physical damage that affects the operation of the business. So tornado comes through and there's property damage, and because of that property damage, the business can't open or function meaningfully. That's what a typical loss of income insurance policy is going to say. Well, COVID-19 isn't causing physical damage to business premises, to business property. So it's not going to be something that's going to trigger a loss of income insurance policy. Also, loss of income policies will specifically exclude transmitted diseases and viruses from coverage. Again, if it's one that requires physical damage, again, not going to occur, but their disease or virus is something that is typically carved out as a triggering event.
So, Lauren, you talked about force majeure in the context of leasing. Does it have any application in like large events like concerts or any other type of big event where a lot of people are going to really get excited about it and then something happens?
Well, this may be different on a couple of different ways, because force majeure may well be invoked if an event has to be canceled unexpectedly, again, that unforeseeability, because it really would be impossible to perform. And I take performance pretty seriously. The best example of this is a concert. If concerts are banned, there is no way that can be done. Now, there's been some online concerts and some band together, actually, that happened I'll say in Raleigh, to be able to take that. But really, the concert experience can't happen, so that may well be impossible and unforeseeable. On the insurance side, there are also endorsements available under policies for special events. That's extra protection that's got to be specifically negotiated. That's why it's in the endorsement and not in the regular policy, but that is a possibility. And so for those reasons, a special event might be a different story than say, in a lease.
Okay. Well, we're running out of time, but there is still one issue I want to cover. So Gene, what happens if I've got a contract and now we're in COVID-19, but my contract, I looked through there and there is no force majeure clause?
Mm-hmm. Well, that's not surprisingly another question that we're getting pretty commonly. And really, if there's no force majeure clause in a contract, then a lot of the issues that we've talked about here already just kind of go away. So issues like, is an event truly a force majeure, or is it truly unforeseen? Those issues all go by the wayside because, again, they're so critical in enforcing a force majeure clause that's already in there. If you don't have one in there, then you don't worry about that aspect. Again, it's a specific contractual provision, and it's either going to be enforced or it's not going to be enforced, depending on how it's drafted and depending upon the facts of the case. Now, does this mean if you don't have a force majeure clause in your contract, or if it isn't enforced, is the party that's seeking to be excused because of COVID or because of a similar kind of event, does it mean that they're out of luck? And the answer, thankfully, is no. There's some general contract law principles that can be relied upon even where there's not a force majeure clause: impossibility, impracticability, frustration of purpose. So frustration of purpose is basically a fancy way of saying there's no point in performing the contract because the basic reason for performing it is gone. A party, even where there's not a force majeure clause in a contract, can still rely on those general principles to at least try to be excused or relieved from performance.
I think I remember something about that in law school. It was that there was a guy that rented a balcony to watch some big parade with the Queen, and then it got canceled, but he didn't want to have to pay for the suite. That's sort of like frustration of purpose.
Yes, I mean, if he rented the balcony for that specific purpose, then yes.
So, Lauren, can you tell us a little more about the principles of impossibility and impracticability and frustration?
Yes, but I'm laughing because I know by the look on all of our faces that we were just thinking of that exact balcony example when you said it. So I'm glad you said something about that. So, and I also want to go over a practical matter in that when a party is filing suit over these things, they're generally going to go based on the contract clause first. So if there's force majeure, they're going to claim that. And then as backups or alternative, they'll plead impossibility and impracticability and frustration of purpose as well, just to try to cover everything in case the court doesn't like one of them, but can give them some relief on the other end. So I wanted to throw that in there. Impossibility is, in the sense, largely, as I said before, where performance is going to be impossible because the circumstances actually prohibited or so very significantly delayed it, and that the party just can't perform. Impracticability is a slightly lower standard. The performance doesn't have to be really impossible, but it's got to be impractical because of the extreme and unreasonable difficulty or expense, injury, or losses involved. Frustration of purpose is exactly what Gene said. It's the change in circumstance that makes one party's performance worthless to the other one, because that was the whole reason in making the contract for the first place, the balcony example.
Mm-hmm.
All right, so we go. So Lauren, who should our listeners talk to if they have a question about force majeure clauses or other contract issues?
You should talk to us. Gene
That's
and
right.
I have been doing this. We've been doing it lately. We've been talking a lot with each other about this.
Yeah.
You can find us on the website, smithdebnamlaw.com. My telephone number is 919-250-2126. My email address is like Lauren, Reeves, Reeves, at smithdebnamlaw.com. And we're available and approachable, and we respond.
Yeah, and my phone is 919-250-2231. My email is Chianelli, or ECHIANELLI at smithdebnamlaw.com. And we're here and ready to take questions. So,
Gene, Lauren, I want to thank you both for participating in today's podcast. I want to thank everybody in the audience for listening, and invite you to check out our other episodes that we have. And please subscribe and stay well during these unpredictable times.